Good morning, my fellow Alaskans, and Merry Christmas. We are happy to announce today is the very last day for the Eastman Trial, the Kowalke versus Eastman case that has been going on. This is day 8. This morning we are going to get to hear from the defense and the plaintiffs. In the case, they are going to give their closing remarks this morning. We've had explosive testimony, at least I want to classify it as explosive testimony, given over the last 7 days now. That's if you're counting the first day of getting nothing done. But they have rapidly been working towards building their case, trying to claim that anybody that is associated with anything out there, that you belong to a group and some of their members decide to go off the rails and go do commit some sort of crime, you are guilty by association just because you belong to that same organization. You're just a card-carrying member, but that doesn't matter. You're guilty because you are a card-carrying member. This is the case that's on the line right now. Our freedoms, our choices that we get to make, those who we want to have represent us are being challenged in court. One person thinks that he has the sole discretionary power to decide whose votes and voices matter. Everybody that's inside of Representative David Eastman's territory out there, he is what you would classify a resounding, very staunch. They support him 100%. They voted for him to be back into office again. This isn't his first time. This has happened multiple times now. He has been re-elected back into office. I see them popping up on the screen here. I am not going to go into very much details other than that. Please like and share this video. You are not going to see this anywhere else. This is the closing arguments for the defense, for the plaintiffs, for the Kowalke Eastman case. Our freedoms, our liberties, our elections are on the line. Our elections are to be determined by the ballot, not on the bench. Like, share. They're getting started. I'm going to transition them over right now, make sure their sound is up and running. Sounds like it is.
All right, good morning, everybody. We are on record in Kowalke versus Eastman, 3AN 227404 CI. This is time set for closing statements. We have Mr. Dedukian here by Zoom, representing the plaintiff. Mr. Dedukian, can you hear me?
Yes, I can, Your Honor. Good morning.
Good morning. We have Mr. Miller here representing Representative Eastman. Mr. Miller, can you hear me? Mr. Miller, you're still on mute. Do we need to have the phone call to you? And I'm still not hearing Mr. Miller coming through. Ms. Harrison, I do see you there representing the division. Can you hear us?
Yes, I can hear you fine. Can you hear me?
Yes.
Thank you.
Yeah, it looks like Mr. Miller is going to be calling in. So, Madam Clerk, just let us know when, keep an eye out for the phone call joining in. Mr. Miller, can you hear us now?
I can, Judge. Thank you very much.
All right, the parties, well, before we get to the closing arguments, I just want to, I did receive the filings, the supplemental briefings from both the plaintiff as well as from Representative Eastman, as well as the motion for reconsideration on the evidentiary ruling regarding the statements against penal interest. Were there other filings that had come in?
Yes, Judge, there was a notice of supplemental authorities that we filed this morning.
Yes, I did see that as well. Sorry, I forgot to mention that. So that was also sent in. Anything else to take up before we move on to closing statements?
No, Your Honor.
Not from Defendant Eastman, Judge.
All right, so as we discussed yesterday, we'll 30 minutes to each party. Mr. Dedukian, you can reserve since you're the plaintiff if you would like to have rebuttal. Do you have a specific time you want me to let you know you're at, or?
Yes, Your Honor. I'm going to aim to reserve 10 minutes for rebuttal.
All right, understood. Whenever you're ready, you may begin.
Thank you, Your Honor, and may it please the court. I want to start by thanking you for your time and attention, not only this morning, but over the course of this 6-7 day trial. I want to go back to the two elements that we have always been coming to throughout this case that the court set out in its summary judgment ruling. The two elements were, is Representative Eastman an oath keeper? And the second is the Oath Keepers an organization that advocates concrete action to overthrow the US government or has actually engaged in such conduct? In the middle of trial, the court hinted at a possible third element, which would be some sort of nexus between Representative Eastman and the illegal conduct on January 6th. I want to start with the two elements and then address the third one at the end of my comments. Both the law and the facts as to the possible third element. The law was addressed in our supplemental briefing, so I'm mainly going to focus on the facts. With regard to those two elements that were the core of this case, the first one, as the court has noted, is not genuinely disputed by Representative Eastman. He admitted in court that he was and is a member of the Oath Keepers, and he has no present intention to resign or disassociate himself from the Oath Keepers. We think that clearly satisfies the first element. The second element was the focus of our trial, and we proved a combination of words and actions by the Oath Keepers that go well beyond any First Amendment line of protected speech and clearly show a conspiracy by the Oath Keepers to overthrow the United States government by force. I want to start with the testimony we heard from Dr. Eastman yesterday, because he looked at many of the Oath Keepers statements individually or one by one, and he gave his opinion on whether each statement crossed the First Amendment line. What was remarkable in his testimony is that he admitted that some of the statements did cross the line, but it was also noteworthy that in his testimony yesterday and in Representative Eastman's supplemental brief, they completely ignore the Oath Keepers' actions leading up to January 6th. And it's completely understandable why they do that, because there's really no defending the Oath Keepers' actions on January 6th. It's well settled that the First Amendment does not protect violence. It does not protect seditious conduct. And what the court knows today is that 5 Oath Keepers have either been convicted or have pleaded guilty of seditious conspiracy charges. So again, if we were looking at only the statements of the Oath Keepers and the statements individually, as Dr. Eastman testified yesterday, this might be a closer case, but that's not what we have. We have the statements collectively, starting even before the November 2020 election and leading all the way up to the January 6th riot and past the riot. And we also have the actions. And when you consider the words and the actions together, again, the picture becomes very clear. The Oath Keepers told us what they were going to do in a lot of detail, and then they went and did it on January 6th. It was not a surprise to anybody what happened on January 6th if they had been following the statements of Rhodes and the Oath Keepers in the 2 months that preceded the events of that day. So even though I said that the court should be looking at the words and the actions as a collective whole, I think when talking about them, obviously we need to talk about them one by one. So I want to start with the words and then get into the actions. As far as the words and the rhetoric of the Oath Keepers, we put on evidence of a combination of public statements, statements that were made at speeches and to journalists by Stewart Rhodes and other Oath Keepers, and also in private communications in the encrypted chats like the old leadership chat and the DC Ops chat and other private chat groups that the Oath Keepers leaders were involved in. But the words and the message were the same across all of these platforms. The message was consistent and it called for President Trump to do certain things. The main thing that the Oath Keepers were calling for was for Trump to invoke the Insurrection Act, but also to do other things like to release state secrets on pedophiles in government, to fire Attorney General Barr and other people who were not playing along with the message of a stolen election. And there were various other details that were set out in the open letters and in the other communications. But the important point here is that the Oath Keepers understood that President Trump might not do what they were calling for him to do. And the message was consistent, again, across all of the platforms, across all of the posts, that the Oath Keepers were going to fight either way. They were going to fight whether or not the Insurrection Act was invoked. They were going to fight whether or not, I think the words that they used were, if the president fails to do his duty, they were going to fight, and there was going to be a bloody revolution. And there are numerous examples in the record. Dr. Eastman testified about a lot of them yesterday. In the interest of time, I just want to highlight 5 of the statements that we put before the court. The first one is the old leadership chat that was at transcript 73, 74, and 75 of the transcript from the Rhodes trial that we covered yesterday. And this is what Rhodes said in that chat to his leaders, the people who were at the Capitol on January 6th. He said, "We must now do what the people of Serbia did and march en masse to the nation's capital." He then linked to a video from a Serbian rebel, which basically outlined, quote, his advice to us and set out a step-by-step plan for how to stop the transfer of presidential power. It included things like having millions of people gather in the Capitol. It said that there would be no barricades strong enough to stop them. And the last step was storming the parliament. So that's eerily similar to what actually happened a short while later on January 6th. There's also the virtual meeting on November 9th. You heard testimonies from Stewart Rhodes admitting to the statements he made on that call, where he called for a bloody, bloody civil war. And you can call it an insurrection or you can call it a guerrilla fight if the president didn't do his duty. Or the way he put it was, if the president didn't do what needs to be done to save the country. Then there's the first open letter, that's Exhibit 18, that was admitted, where he said, Rhodes said, "We are in for a fight no matter what, and that if Trump did not follow the Oath Keepers' advice, we the people will have to fight a bloody revolution / civil war to throw off an illegitimate deep state Chinese puppet regime." The second letter, published about a week later, Exhibit 19, again called for a bloody revolution, and again told Trump that if he didn't do his duty, which again was to invoke the Insurrection Act and release state secrets about pedophiles in government, that the Oath Keepers and other patriots would have to, quote, walk in the founders' footsteps and, quote, take to arms in defense of our God-given liberty. And then finally, there's the communication between Rhodes and General Counsel Kelly Sorrell, that's at transcript 7396. And in that text, Rhodes said, quote, "Either Trump gets off his ass and uses the Insurrection Act, or we will have to rise up in insurrection, and in parentheses, rebellion, against the Chi-Com puppet Biden." And again, there are many, many other statements in the record. We don't have time to go through all of them, but an important point is that these statements started before the election. For example, the statement given to InfoWars in late October, and continued even after the riot on January 6th had subsided. There was testimony from Rhodes yesterday about comments and statements that he made at the Olive Garden restaurant and in private texts, not giving up the fight, not telling his people that we were done with the insurrection, but urging them to continue and move forward. So let's turn now to the actions. And I think the court can clearly discern what happened on January 6th by looking at the convictions and the indictments that inform the convictions, by looking at the inculpatory statements in the stipulations of fact by the Oath Keepers who pleaded guilty, and by considering the expert testimony from John Lewis and Matt Kreiner. And you did also hear eyewitness testimony from defense witnesses, but frankly, that testimony was just completely unbelievable. You heard testimony from Rhodes. You heard testimony from a person convicted of seditious conspiracy telling you that he and the Oath Keepers did not engage in seditious conspiracy. And he said the exact same things he told the jury in Washington. He said there was no plan, that the people who entered the Capitol were off mission, that they were just in DC to provide security. The jury didn't believe him, and this court should not believe him either. You also heard testimony from another expert, John Guandolo, that was even more unbelievable than the testimony you heard from Stewart Rhodes. At least Rhodes, to his credit, admitted a lot of the statements and actions that he did before January 6th. Guandolo's testimony was that what happened on January 6th was a false flag operation, that the people committing violence on January 6th were Antifa, and other than the Antifa people that were there, the atmosphere was jovial and like a tailgate party. Even Rhodes testified yesterday that the people who were storming the Capitol and committing violence on January 6th were not Antifa. They were patriots. They were Trump supporters. There's absolutely no credible evidence in this record that anybody other than the Oath Keepers and the other people who marched to the Capitol from the Stop the Steal rally were the ones storming the Capitol. And you heard the rest of his opinions, like the fact that Mitch McConnell is a Chinese spy, that his marriage to Elaine Chao is a counterintelligence operation for China, that the Secretary of Interior is a communist. I think, and frankly, you saw the video at the end of his testimony of his comments the day after the insurrection. So the court should give zero weight to the Guandolo testimony. It was probably the least credible and most outrageous expert testimony I've ever seen. Now, if you look at, like I said, the convictions, the statements of offense, the expert testimony, I think and Rhodes's testimony from yesterday, I think the picture becomes very clear. He saw the 2020 election as an existential crisis for the country. He knew that January 6th was a hard deadline for certification. He was at the Capitol. He learned that, quote, Pence was doing nothing and Trump was just complaining. He was in communication with his men by encrypted chats and telephone calls. And when he learned that Pence was doing nothing, he summoned his men to the Capitol, where they were miles away providing security for various people. He summoned them to the Capitol, and then he claims to have been surprised that they entered the Capitol and committed violence. But what the facts show is that there were two groups of Oath Keepers, at least, who entered the Capitol. They admitted to using force inside the Capitol. They subjected themselves to 20 years prison sentences for admitting those facts. They admitted to assaulting Capitol Police. They admitted to intimidating the members of Congress. And again, it's not just the people, the three Oath Keepers who have pleaded guilty to seditious conspiracy, but the jury also convicted Rhodes and Kelly Meggs. And these are top leaders in the Oath Keepers organization of seditious conspiracy charges. And I just want to say, let's not forget the upshot of what happened in the attack on the Capitol on January 6th. That mob, including the Oath Keepers, achieved what even the Confederates never achieved in a civil war, which was to breach the Capitol building. There were dozens of people who were injured and at least 6 people who lost their lives on that day. Now, in response to all that, the Representative Eastman and the witnesses who testified tried to make a few different kinds of arguments. One, they said that they weren't actually trying to overthrow the government. None of the Oath Keepers were charged with overthrowing the government, and all they were trying to do was just delay a congressional proceeding. That really, again, if you look at the facts and the picture that we painted, is not a believable position to take. We can't speak to the DOJ's charging decisions or why they charged what they did, but what we can speak to are the facts that are established if you look at those guilty pleas and convictions as a whole. These people these Oath Keepers admitted not just to trespassing in the Capitol, they admitted that they were part of a coordinated effort to stop the transfer of presidential power. And again, the indictment against Rhodes and Meggs, the superseding indictment at Exhibit 20, alleged a plot to oppose by force the transfer of presidential power. And of course, they were found guilty of those charges. And as I've argued before, and I won't belabor the point, there's really no functional difference between stopping the transfer of presidential power and overthrowing the government. The intended result of those actions was to keep President Trump in power, was to stop President Biden, a legitimately elected president, from taking power, and having an unconstitutional president go past his term of office is the same thing as overthrowing the Biden administration. The court should find no difference there. And the underlying intent of the conspirators, I think, is crystal clear. The other main argument that I've heard from defense is that the actions of Rhodes and the actions of those who were at January 6th cannot be imputed to the organization as a whole. And again, I think the court, if you look at even the admissions from Rhodes yesterday, I think that argument cannot stand. Rhodes testified yesterday, he admitted that there was a command structure, there were cohesive teams, operations leaders that he vetted, and there were leadership chat groups in place on January 6th. The top leaders of the organization, including the leader of the Florida chapter and the Alabama chapter, were at the insurrection, in addition to Rhodes, the founder and president for life, and Michael Green, who was appointed to be the leader of that particular operation. The planning for the January 6th actions was done using Oath Keepers infrastructure. The communications were posted on the official Oath Keepers website. The calls to action were sent to the entire membership. The participants who stormed the Capitol were displaying Oath Keepers logos. And Representative Eastman has pointed out, or Mr. Miller has pointed out in his questions, that there were only, if you consider the total number of Oath Keepers and the number who showed up on January 6th, it was a relatively small number, and also a small percentage of the total crowd at the Capitol. But that's besides the point. That's how these kinds of organizations work, as Matt Kreiner testified. That's how all terrorist organizations and domestic violent extremist organizations work. When they carry out operations, it's not like the whole membership shows up. I think a good example of that is 9/11. There were a handful of Al-Qaeda people who actually carried out the mission. That doesn't mean that it wasn't an Al-Qaeda mission. And finally, I think the argument that the bylaws should somehow control over the actions is just false. They point out that the bylaws don't allow felons or anyone who advocates the overthrow of the government to be part of the Oath Keepers. Well, first of all, bylaws, the fact that they have bylaws doesn't mean anything. A lot of extremist organizations have bylaws, like the KKK, like Al-Qaeda. And as the court, I think, noted in one of its orders, not using these words, I'm going to use these words, but the bylaws don't trump the actual conduct, or the old saying goes, actions speak louder than words. So you can look at the bylaws and you can look at what the bylaws say, or you can look at what the Oath Keepers actually did. And what the Oath Keepers actually did is clear, and they tried to overthrow the government. And Rhodes, who was spearheading the efforts to overthrow the government, is still a member today. He doesn't have any plan to resign for years until his appeals and post-conviction relief petitions and all of that has been exhausted. So I want to turn to the nexus. Judge, how much time do I have?
About 2 more minutes until 10 minutes left.
Okay, I might go a little bit over and we'll take it out of the rebuttal time. So I won't get too far into the law on nexus because we addressed it in our supplemental brief. I will say that the court has already narrowed the disqualification for disloyalty clause to cover only advocacy that would not be protected by the First Amendment, and that was appropriate to do. We actually suggested that the court do that. We don't think that the plain language should be narrowed any further. I think the limited evidence of intent that we have is clear that the framers intended for membership alone to be sufficient. And also, it's important to point out that we filed a case at the primary stage of the election. The issue was whether Representative Eastman's name could be on the ballot, whether he met all of the qualifications. As we pointed out in our briefing, cases that challenge qualifications requirements do not get heightened scrutiny from courts. They're usually, and the reason for that is because it's well understood that appearing on a ballot or running for office is not a fundamental right. So we don't think the court should incorporate any additional requirements from either the 14th Amendment or the First Amendment into the Alaska Constitution. And to my knowledge, it would be the only time if the court did that, that any court would be striking down any original provision of the Alaska Constitution. That being said, if the court is going to incorporate an additional requirement from the federal Constitution, the one that should be incorporated is the 14th Amendment and not the First Amendment standard. The reason for that is, first of all, Dr. Eastman admitted yesterday that there's not even one example of any court anywhere applying the specific intent standard to a political qualification or legislative qualification requirement. The few cases that have addressed this issue have all applied the 14th Amendment standard because it's much more specific to this particular context. And I think there's a well-settled rule that the specific provision governs over the general provision. The standards are pretty similar. One, the First Amendment requires a showing of specific intent, and the 14th Amendment requires a showing of engagement in or engaging in insurrection. So I don't think there's much of a difference between the two, but I think the 14th Amendment makes sense because it's more specific. It deals with this situation, and there's some case law applying it in this context. And so whichever standard the court applies, I think we've established a nexus between Representative Eastman and the insurrection on January 6th. We can start with the public statements that Representative Eastman issued before January 6th, consistently saying that Congress should not certify the election, that the election was fraudulent, the same message that was being given by the Oath Keepers and the same message that was being given out by President Trump. There was some dispute at trial about what specifically motivated his trip to Washington, whether it was the call to action or whether it was Donald Trump summoning his followers to Washington, D.C. Ultimately, I don't think it matters which of those two things motivated Representative Eastman to go to Washington, because Congress and at least two other courts, the Eastman Court from California and the New Mexico case that we cited in our brief, at least two other courts have found that the Stop the Steal rally was also part of the insurrection. It was part of the conspiracy to incite an insurrection on January 6th. All of these people, the Oath Keepers, Donald Trump, everyone at the Stop the Steal rally, who then marched to the Capitol, they were united by a common purpose of delaying or stopping the certification. And it's also important to show or to note that Representative Eastman did not just go to the rally. He then heeded Donald Trump's directive to march to the Capitol after the rally. And we played some clips from the speech yesterday from Donald Trump telling people at the rally to march to the Capitol and to fight like hell. He testified, Representative Eastman, that he had already decided to go to the Grant Memorial regardless of Trump's speech. But Mr. Martin testified that even before they traveled to Washington, they knew that a large crowd of people was going to be gathering at the Capitol. So the fact that they had made arrangements to take a picture at the Grant Memorial, or whether or not Donald Trump's words motivated them to go there, I think the facts show that they had already decided to go there, and they knew that there was going to be a large crowd at the Capitol. And after the rally, Representative Eastman, quote, led his friend Patrick Martin to the Capitol grounds, or very close to the Capitol grounds, to the Grant Memorial. And when they got there, Mr. Martin was very honest in saying it was readily apparent what was transpiring at the Capitol was not a lawful constitutional approach. And instead of leaving or instead of removing themselves from that situation, and also I should say that they heard from the crowd, or at least Mr. Martin heard from the crowd, that the Capitol had been breached, that people had entered the Capitol building. So it was apparent what was going on. It wasn't a peaceful vigil. It wasn't some sort of peaceful demonstration, much less a jovial atmosphere or a tailgate party. It was, I think the court should credit Mr. Martin's testimony that it was not a lawful constitutional approach. And yet Representative Eastman stayed there. He added his presence to the crowd. He took pictures near the Capitol that were then posted to social media. And he didn't leave the Capitol grounds or Capitol area until the curfew was issued, until everybody was ordered to leave when the curfew was issued. And to this day, even after hearing everything that was put on at trial, even after seeing that Oath Keepers have pleaded guilty to seditious conspiracy charges, that Stewart Rhodes and Kelly Meggs were convicted, he has refused to denounce the Oath Keepers, and not just the Oath Keepers organization, but any individual Oath Keepers, including Rhodes. He refused to say yesterday that Rhodes was involved in the planning of the events that happened on January 6th. It's clear if you look at all of his social media postings that were admitted into evidence that he's tried to use ambiguous language to not make it clear who he's calling out and who he's not calling out. But when he was questioned, and when you look at his words, he called out Antifa, he called out other groups. He has refused to call out the Oath Keepers. And when I specifically asked him if the words he put on social media was intended or aimed at the Oath Keepers, he said no. So I think based on his actions and inactions, we can show that there was a specific intent to be part of the insurrection on January 6th. And for that reason, I think certainly that would satisfy the Section 3 of the 14th Amendment. And anything that satisfies the 14th Amendment as a matter of law cannot violate the First Amendment. And so I think that to the extent the court had concerns that just applying the plain language of the Article 12, Section 4 would violate federal law, I think the answer to that is no. So the court should apply the language as written and as intended by the delegates to the convention. Just very briefly, I want to touch on the state. I think my understanding is the court granted a trial or is treating this as a trial de novo against the state. And so therefore, if the court finds that Representative Eastman is disqualified from office, that should automatically reverse the division's decision finding him eligible for office, which would mean that he never should have appeared on the ballot for the general election. Unless the court has questions, I'd like to reserve the rest of my time.
No, thank you. Mr. Miller?
Yes. Well, I mean, I want to start with the big picture. First, there is not a scintilla of evidence that the Oath Keepers as an organization tried to overthrow the government. Plaintiff has the burden in this case here, didn't satisfy it. Of course, I'm not going to re-argue what we moved this court early on for the directed verdict. We believe at the conclusion of plaintiff's case that the evidence, sufficient evidence to satisfy that burden had not been presented. There have been some reports in the press, and Your Honor, I know that you aren't relying on those, that there are parallels, in fact, direct parallels between this case and criminal cases that have previously been litigated, but all parties in the court had cautioned drawing too many parallels because this is a speech case. This is not a case as to whether or not somebody committed a crime or whether or not somebody committed obstruction against government. This is a case involving whether or not Representative Eastman's membership in an organization can disqualify him from public office. And there are significant First Amendment concerns surrounding this decision and significant implications, not just for Representative Eastman, but many, many other individuals who are public servants today and who wish to be public servants in the future. This approach to Representative Eastman, I think we've seen some of the color of how this is proceeded from the outset. one of the foremost experts. And again, plaintiff's case was brought entirely by experts. The only fact witness brought in by plaintiffs was Representative Eastman himself. And so basically half of the evidence presented by plaintiffs supported by Mr. Lewis is an individual who called my client anti-Semitic, racist, and called the Oath Keepers a terrorist group. Now, these are extreme statements, unsupported by the facts. And the reason I bring the court's attention to those statements is because it reflects upon the expertise of that individual. If you're going to, with very thinly sourced information, draw conclusions of that nature, then the whole of the rest of the opinion should also be rejected. I want to talk briefly on delay. This case and where we're at today, and kind of the accelerated nature of this case, which of course was primarily impacting adversely Representative Eastman, because it was he who was given notice of this case, given only several weeks to come up with experts, given no time at all to raise funds in the middle of the campaign. It's he who was primarily prejudiced by this. And yet, this case could have been brought well over a year ago. In fact, when the Oath Keepers membership list was leaked, is when supposedly this evidence that Representative Eastman belonged to an organization that advocated by force or violence for the overthrow of government. And yet, despite that, Representative Eastman has put on quite a case. Of course, there's been an attack on one of his experts, Mr. Guandolo. I'll address that here in a moment. But again, unlike plaintiffs who had months and months and months to prepare, who knows when it started, all of our discovery requests were rejected. The reality of it is the overwhelming evidence in this case is that Representative Eastman does not belong to a group that advocates by force of violence the overthrow of government. And even if the court disagrees with that contention, there are First Amendment protections that fully insulate Representative Eastman from any adverse finding in this case. So let's talk about the burden and what the plaintiff has to prove. First, of course, the plaintiff has to prove that Oath Keepers is an organization that advocates by force or violence for the overthrow of government. That's consistent with Article 12, Section 4. And I'll get to the evidence here in just a minute. Let me continue with the other things that plaintiff must prove. Second, they have to prove under Claiborne that Representative Eastman knew when he joined the group that the Oath Keepers is an organization that advocates by force or violence to overthrow government, or if the organization changed that mission at some later point. And third, that Representative Eastman has held a specific intent to further those illegal aims. And again, that's NAACP versus Claiborne, 458 U.S. 886. And Judge, we briefed that in our supplemental briefing. We submit, Your Honor, that plaintiff has come nowhere near meeting those requirements, meeting his burden. So looking at the evidence, again, plaintiff's case is built virtually entirely on so-called expert testimony. Called one fact witness, as I mentioned before. Nothing in Representative Eastman's testimony came anywhere close to satisfying their burden, but let's look at the experts. So with respect to Mr. Lewis and Mr. Carter, they both admitted that they have never, not once, interviewed or even spoken to one Oath Keeper, not one. They admit to Exhibit U, which are the bylaws, rules, regulations of the organization. They admit to the mission of the organization. They admit that the organization had as its very mission upholding the Constitution, but they say that doesn't matter. Importantly, in offering their opinions, both Mr. Kreiner and Mr. Lewis admitted that they are not legal experts, yet their entire reports are an attempt to apply a legal standard to facts that weren't even in evidence. They were incredibly biased or sloppy or failed to offer expert testimony in a number of ways. Your Honor will remember, I asked the experts regarding the humanitarian outreach that was done by Oath Keepers. They didn't know anything about that, nothing at all. And yet that's a major component of the organization's work. It started coming out of Hurricane Katrina. That was the testimony of Stewart Rhodes. And had they done even a little bit of research into anything other than the negatives that they focused on, and I should also note that those negatives came from where? Groups like the Anti-Defamation League, ADL. The testimony from the experts was that the group that actually evaluates these so-called insurrectionist groups is very small. It's 1 or 2 dozen people. We would submit, Judge, that it's incestuous. In fact, if you look at the experts that they rely on, they're more of themselves. You look at the articles that the experts relied on. many of those articles, in fact, well over a dozen of them, were written by the experts themselves. So relying on their own opinions to reach their opinion. But again, this begs the question, did they really have the authority, even if from an evidentiary perspective, they had the right to bring in this evidence that the court then relies on? Did they have the basis from which to testify? And again, not even close. I mean, no oath keepers, none interviewed, none spoken with. What do they look at? They look at their other fellow experts' reports. They aren't aware of all the humanitarian outreach. I think that Mr. Rhodes testified to the fact that there were 14 hurricane relief missions, a number of other disaster relief missions. No mention at all from the experts regarding the Oath Keepers and their support to Houston, the fact that the Houston mayor hugged Stewart Rhodes as a consequence of the work that he did there and the aftermath of the hurricane in that area. Again, these are public records, things that they had accessible to them, but they chose not to talk about it. Why? Well, because like Mr. Lewis said, this is a terrorist organization. I mean, that's literally what he said. And in fact, that's what opposing counsel just characterized Oath Keepers as, a terrorist organization. 38,000 people, most of them military veterans, a third of them almost, according to Stewart Rhodes' testimony, active or retired cops, and they're a terrorist organization that has worked historically since 2009 with law enforcement agencies throughout the country. And what can the experts do? Well, they can point out one or two things, right? They can point out that, hey, the sheriff, they didn't even characterize him right. They said it was a police chief. It was actually the sheriff in St. Louis County criticized the Oath Keeper for the work that happened in Ferguson. Why? Because that individual was embarrassed by their work. Oath Keepers actually protected. They were there on top of the building protecting residences in that area, protecting a black bakery, black-owned bakery business. Again, this is supposedly the organization that, again, I understand their experts backed off of this, but supposedly has all these racist members in it. Of course, led by an individual that's a minority himself. There's way more than that, though. I mean, they're talking about the military tactical gear. They talk about stack formation. Every individual with any type of military expertise that came before Your Honor that commented on stack formation said that's not a military term, completely contradicting what the experts said. Another thing that was completely avoided, except for in the context of January 6th, was the fact that Oath Keepers have performed over the course of the 10 plus years they've been in existence, numerous security functions. Not even aware of it, apparently. Again, how can experts, so-called experts on the Oath Keepers, not be aware of the enormous humanitarian relief that's been done by that organization, the numerous security functions, and call themselves experts on it? No, what they're doing, Judge, is they're focusing on one event, and they're focusing on a small group of people. And then they're trying to paint this broad brush of blame over anyone that has any association with them. I mean, completely and directly contrary to the First Amendment, contrary to the very foundation of this country, that somehow we're going to blame people that have some sort of association with the group and then bar them from public office. I mean, I mentioned at an earlier hearing a number of months ago that it seems like we're going full circle back to the communist era. I mean, that's not who we are. We're a free nation. We don't blame people for their associations. And I'll submit, and we'll get to this here in a minute, Article 12, Section 4 has nothing to do with that anyway. Again, focusing on a small group, that's what they've done. Focusing on January 6th, that's what they've done. Focusing on the statements of Stewart Rhodes, that's what they've done. All the focal point on January 6th, plus, of course, all the stuff that they argued, and I would submit, Judge, just completely false testimony. I mean, suggesting that the events that the Oath Keepers are part of, 20% more violent. I mean, you heard the testimony from Stewart Rhodes, and there's nothing in the record, save what we've seen in January 6th, of even one arrest or conviction of an Oath Keeper over the course of the dozens upon dozens of events that they participated in since 2009. Not one. So for them to suggest this is some sort of violent extremist organization that has this long history, again, reflects the utter baselessness of these experts' testimony. And that's part of the reason why I urge Your Honor to look at the information regarding the biases that were in Dr. Eastman's report, because the only way you can reconcile the vacuous opinions that they've offered is that they're approaching this with extreme bias. And that's kind of marked this whole January 6th thing. I mean, there is a move afoot in this country today to demonize anyone that contested that presidential election. Now, in contesting elections, the democratic process is foundational to our country. That's what we do as Americans. We don't just bend our knee to authority and say, yes, sir, even when we see things that are wrong. The marking features of a democratic society is speech, even speech that's unpopular. And we've heard a lot of that here. Unpopular speech is not to be restricted. And even in the context of this case, speech advocating for force or violence to overthrow government is constitutionally protected. Now, we'll get to actions here in a minute, because I know there's a distinction. But I just want to emphasize here that what plaintiff is asking the court to do is to severely limit speech in this country. And again, of course, I recognize the jurisdiction of this court, and the impact is here at a state level on Representative Eastman. But trust me, this case is far bigger than Representative Eastman. And we see this type of action going on throughout the country. In fact, plaintiff mentioned in his supplemental brief the New Mexico case involving the county official that was barred from office. And I'll talk to that because we don't say anything in our briefing about it. I mean, this is a guy who also, up against all odds, pro se in his litigation, there was a finding at the trial court level against him. It's now on appeal. We'll see where that goes. And hopefully he raises the First Amendment issues, which he as a pro se didn't have the capacity to do. It's a real burden on the people that are at the point of the spear on these anti-First Amendment cases that are designed to punish people for their political views. But we believe that's what motivated those experts' opinions. Let's talk about our experts for just a minute. John Guandolo, we heard his testimony. Now, again, we had this video that was played at the end, suggesting bias. Of course, we tried to go there with their experts. That testimony was excluded by Your Honor. Not trying to re-argue that, but that's exactly why they provided that video, to show that, hey, Mr. Guandolo, he was animated, he was upset at January 7th, said some things that, what we heard from opposing counsel was insurrectionist itself. It actually was free speech. I mean, that's exactly what we're getting at here. And I think his testimony, or not testimony, but that video actually reflects how important these issues were to him. But the important aspect of Guandolo is that he was an FBI agent for a number of years, worked in counterterrorism, evaluating domestic threats, and he's the only one that testified before this court, other than Stewart Rhodes himself, who has literally talked to hundreds of Oath Keepers. He knows what was important to Oath Keepers, their oath to the Constitution. I mean, explicitly, the aim of the Oath Keepers is to support the government, to support the Constitution, the underlying document by which government is formed, by which government has its power. Yes, he was activated. Yes, he was angry on the 7th, but that should not cause Your Honor to disregard his testimony. He was not impeached in any way regarding what he testified to. There were some efforts to do so, and certainly trying to cause the court to see him as somebody that, like millions of other Americans, and I would submit again, the majority of the Republican Party, very upset about the fact that the vote results needed to be looked at, they needed to be confronted. But getting to the plan itself, and I'll talk about that in the facts, that plan itself didn't exist in anybody's mind organizationally, and certainly is not something that the court should act on. John Eastman's testimony, before I get to facts, just touch on that briefly. I think his testimony was very helpful to the court in understanding the legal issues before it, and our supplemental briefing, I think, provides an adequate basis. I don't think I need to go through that with Your Honor. I would note that we filed the supplemental authority. There was a case that was cited by plaintiff in his supplemental brief where he failed to cite the subsequent authority. It's the Congressman Green case. It's important, Your Honor, that you look at that because it reflects that the holding that plaintiff cited the Green case for was not upheld. So looking at the evidence, let's look at the organization for a moment. Again, what's being presented by plaintiff is that it's a foregone conclusion that Representative Eastman is a member of the Oath Keepers. Well, I don't think it is, Judge. I mean, he has admitted that he signed on for a lifetime membership. But one of the things that was not admitted was that we have an active organization. And I think the only evidence before the court is that it is now a dormant organization. And I fall back to what I directed the court to before the current state, the present tense of Article 12, Section 4. It requires current membership. And what we heard from Stewart Rhodes, he's in solitary confinement. He's been there for almost a year. He can't direct or organize the group. He handed it off to Colonel Siemens, who's had strokes and is too sick to participate in this case, was too sick to participate in the criminal cases. We heard from Representative Eastman, and you have the exhibits that are admitted, where he contacted the people that he thought were board members of Oath Keepers, did not receive one response. There's not been one email. There's not been one web posting for months and months and months. So I would submit to your honor, organization is dormant. So you can't really be a member of an organization that advocates by force of violence to overthrow government when it's dormant. And that also goes to Stewart Rhodes and his leadership. I mean, Stewart Rhodes himself has said that he's not a leader anymore. He is in solitary confinement. And so as a consequence of trying to kind of amalgamate or conflate the Oath Keepers and Stewart Rhodes, that doesn't work. Just like conflating Oath Keepers with the 50 or 60 people on Capitol Hill that were part of all this speech. That doesn't work. And Judge, how much time do I have?
10 minutes left.
All right. So, and I'm talking about that speech. I think I ought to touch on that briefly. It's critical, obviously, but we'll also go to the actions themselves. Every element of speech that's been provided, the 5 that were given, are all contingencies. If you listen to what plaintiff's counsel said, they're all contingencies. If you, for example, say that there is going to be a bloody civil war if, well, what does that mean? It's a contingency. It's certainly not incitement. We're going to be in a fight if Trump doesn't do it. Yet another contingency. Calling for a bloody revolution. He never directly said, we've got to have a bloody revolution. No, it's all contingent. Abstract, political speech. What we have to do now is what the people of Serbia did. They marched on the Capitol. And then, of course, linking to a video. That's how they get there, right? They link to a video. But in fact, the march on the Capitol was the reference point. And again, what was the date of that? Well, that was way early on. It was weeks, months before the January 6th event. I think that in addition to that, with respect to any of the speech that may cross the line to incitement, again, incitement to violence is not incitement to overthrow government. And it's also, by the way, protected speech, but not incitement, obviously imminent. But what I'm saying is that if you obstruct government, that is not per se overthrow government. Now, I understand Your Honor's concern and what has been stated previously in this case, but even plaintiff's expert Kreiner said it's tantamount to overthrow government. He wasn't even willing to go all the way and say, hey, it's overthrow of government. But in looking at, even if it was delay of certification, let's just say that the incitement to action, if Your Honor finds that there was incitement to action, not protected speech, and that it resulted in some sort of effort to delay the certification. Again, how is that not? Now, let's just talk about delay of certification for a moment. I want to focus on that for just a minute. There's been testimony in the court that in every presidential election, at least for the last 20 years, there have been efforts where a Republican has been elected to object and introduce evidence and therefore delay the certification. And delaying doesn't mean overthrow. Obstructing doesn't mean overthrow. And I think it's an important distinction. And the reason why you don't find overthrow in the almost 400 pages of indictments and statements of offense and plea agreements that are part of Exhibit AA that have been filed and admitted with the court. And again, we disagree with the truth of that matter asserted, but certainly you can see what they're charged with. Is because the government knew it couldn't prove that charge. And it wasn't even a close call because there was no statement about overthrowing the government. In fact, Oath Keepers itself, as its very organizing document, Exhibit U, the bylaws say, we're there for one reason, and that's the oath to the Constitution. And that's why people join it. I mean, a lot of the Oath Keepers, like Representative Eastman himself, I mean, he didn't have had contact with other than these few emails that he received from Stewart Rhodes. And of course, those were just general formatted emails. They weren't personal emails. He didn't identify with Stewart Rhodes in his association with Oath Keepers. Oath Keepers to him, the first reason he was an Oath Keeper was because of Oath Keepers little o, little k, not the organization, because he saw his oath as critically important. And that's why he joined the organization, because that's what the organization stood for from his perspective. And the bylaws are important, Jen. He said that. Obviously, we still have some time before these convictions become final. There's an appellate process. But Representative Eastman has even demonstrated, given his allegiance to those bylaws, that look, if ultimately they aren't followed, and there's been evidence they have, by the way, to date been followed. Stewart Rhodes testified that felon members that have been felons convicted have been removed from the organization because it violated the organization. Now, whether or not other people have since been removed, we don't even know because, again, the organization is effectively dormant. Representative Eastman has not gotten any responses to the letters he sent. And so, again, that's yet another reason why the burden is not met here. But looking at the actions themselves, again, we have two groups of Oath Keepers that went into the Capitol. I believe that Stewart Rhodes' testimony was persuasive and it was credible. His testimony was not impeached. He said, I never told them to go there. I never told them to go into the Capitol. The testimony from two different witnesses was that the first group that went in because somebody had been shot. And again, according to Stewart Rhodes, off mission. They didn't go in under his direction. It was off mission. The second group, the smaller group, went in, again, not under the direction of Stewart Rhodes, again, off mission. And what did they do? Well, according to Michael Nichols, they were there, well, not Michael Nichols, but Stephen Horn, they were there protecting the Capitol Police in a room off of the rotunda. Michael Nichols testified that he and another Oath Keeper actually assisted Capitol Police evacuating from the Capitol. And so, if we're going to say that we're going to conflate the actions of these two Oath Keepers with the Oath Keepers as an organization, well, I mean, you got to take it all, right? And you also had Oath Keepers that helped the Capitol Police, besides those that went in and were there unlawfully. Now, as far as any specific acts that went on within the Capitol, again, I don't think there's been any evidence to the court that the court can consider regarding individual acts by these two groups that went in that would constitute violence. Now, nobody is suggesting to the court that there wasn't violence on the Capitol on January 6th. I'm not saying that. But again, the effort here is not just to conflate Stewart Rhodes and what he said, the unpopular words he said with Oath Keepers. It's not just an attempt to conflate these two groups that came in and, of course, exclude the good things the Oath Keepers did. It's also an attempt to conflate everything on January 6th, of course, all the bad things that happened on January 6th. Now, we want to stay away from, of course, the rally, because the rally, the tailgate, the jovial atmosphere, that doesn't fit that whole thing. But we want to conflate everything else that's bad with the Oath Keepers, including the 900 people that were charged. And I do think it's important to point out that, you've got 900 people charged and less than 4% of those are Oath Keepers. And again, none of those Oath Keepers charged with overthrowing the government. Let's look at Representative Eastman's actions. So Representative Eastman, I think his speech goes without saying, all protected speech, nothing even comes close to any boundary of overthrow of government or even advocating violence. Clearly not satisfied with the election. I mean, as a huge number of Americans weren't satisfied by the election, including a majority of the Republican Party. And I don't think we're going to call a majority of the Republican Party insurrections. At least I hope not. Hope we aren't going down that line. Although I know that there's been some commentary that suggests we should. The fact of it is that he made a number of statements. He wrote a number of articles, might not like those articles, but none of them advocated by force of violence overthrow of government. None of them advocated for the overthrow of government. He just wanted a clean, fair election. He felt the laws had been violated. And I think the records honor they had been. Whether or not it's enough to change the outcome of the election, Representative Eastman didn't know. He just wanted the laws followed. And that's what millions of Americans wanted as well. I think that's why millions of Americans were at the Capitol on January 6th, was because of that, supporting the president. Now, again, going to the action themselves, because I think that's one of the focal points, or the focal point of the court in this case. Representative Eastman went to Washington, D.C. He went 2 days before January 6th. Again, contrary to the written briefing of plaintiff in this case, he did not receive the Oath Keeper email and then go to Washington, D.C. That's just flat out false. He decided to go before. He wanted to hear from President Trump. We saw the tweet that he responded to. That's consistent with Pat Martin's testimony. And it, frankly, is why I went to support the president, hear the speech, a momentous occasion. And then after the speech, after the rally, which was a jovial tailgate type affair, I mean, Your Honor saw the videos. It wasn't insurrectionists in form. In fact, as Pat Martin testified at the end of that speech, what was played? YMCA, not exactly an insurrectionist, a call to insurrection or a call to riot. Well, there was a march from that rally that went to the Capitol. Guess where Representative Eastman and Mr. Martin went? Well, they went to the subway. They didn't go on the march. They went a different route. And where did they go? They went to Grant Memorial, some distance away from the Capitol. Why were they there? They took pictures with their constituents. And then later, Representative Eastman didn't leave, not because he was part of an insurrection, which, again, not a scintilla of evidence there was any insurrection, even anywhere close to where Representative Eastman was. Representative Eastman said he didn't see anything. Pat Martin's perspective was a little bit different. Of course, he had a camera with a telephoto lens. He could see things differently than what Representative Eastman could, but they weren't there participating in any type of riot. Now, they did say they saw some people there. Thank you, Your Honor. They did see what they saw to be potentially provocateurs, and of course, the testimony in this case is littered with examples of provocateurs who were there doing things that have not been charged, convicted for what they were doing. But again, I think just like the rest of the crowd, Your Honor, that really is outside of the core issue. Was Representative Eastman there supporting the so-called insurrection? Again, that's kind of a legal term, right? And I don't think there's any finding of insurrection. I don't think that anyone would suggest that all the hundreds of thousands that were there with the president were insurrectionists. They were supporting their president. They were assembling as the First Amendment allows. They were using their speech as the First Amendment allows. And in fact, some were protesting, and the 99% of them were protesting in a lawful manner. And again, Representative Eastman was part of that group. Is part of that group at the Capitol, at Grant Memorial, a distance away on the other side of the Capitol from where all these other things were occurring, completely disconnected. So can't paint him with a conduct brush by any means. And you certainly can't, under Claiborne, paint him with this idea that he had, first of all, any knowledge at some point that this group had changed into a group advocating for force or violence over the government, which we aren't even at this point, right? You just have a few people that they're trying to ascribe to the whole. The organization remains, again, we think in a dormant context, but governed by its bylaws. That's what the 38,000 members follow. That's what the unrebutted testimony says from the people who have talked to the Oath Keepers. Mr. Guandolo, Representative Eastman's own testimony, as well as Stewart Rhodes' testimony. So, granted, Judge, there's some speech that is not nice. It's unpopular. That's what the First Amendment is there for. You don't get excluded from office just because you're a member of a group or a member or even 50 members of a 38,000 member group do or say things that we don't like. The fact of it is that
we're out of time, so it's time to wrap up. I'll let you finish, but it's time to finish up.
All right, Judge. Well, we submit it to your discretion, Your Honor. We read that the quote from Thomas Jefferson. The speech that was used, they may not like, but it's certainly considered to be speech that this country has denoted as protected by the First Amendment since its founding, and we ask that you continue the protection of speech and assembly that are guaranteed under the Constitution. Thank you, Your Honor.
Thank you, Ms. Miller. Ms. Harrison?
Thank you, Your Honor. This court just heard a week of testimony that addressed some of the most divisive political issues facing our nation. And I think the testimony that we heard really exemplifies why the division of elections should not be tasked with gathering this kind of testimony or information and evaluating it. This is very politically charged material, and the legislature has designated the division of elections as an impartial, politically neutral entity. The division's role is to administer elections. It's not to investigate candidates' political beliefs or investigate organizations' political beliefs or investigate the connections between candidates and organizations' political beliefs. The division has to remain neutral in order to fulfill its statutory duties and also in order to maintain that credibility with the public of its neutral, impartial role. And even now, after hearing all this testimony, the Division of Elections is still not going to take any position on the topics that we've been hearing about, on the question of whether or not Representative Eastman is disqualified from office by Article 12, Section 4 of the Alaska Constitution. We just want to reiterate what we've been saying from the beginning, that in June, the Division of Elections did not have proof of Mr. Kowalke's allegations that could have justified removing Representative Eastman from the ballot. Removing a candidate from a ballot is a very serious matter, and it's not something that the division can do on mere allegations or thin evidence, based on just a request from a member of the public, and the process is set up to avoid that happening. So at that point in June, when the division made its administrative decision, the division did not have reliable evidence to suggest that, or to establish that Representative Eastman was disqualified, and it didn't have the means to obtain evidence. And so the division properly denied that administrative complaint, as we've repeatedly argued and emphasized. Now, this court, sort of at the last minute, made a ruling that kept the Division of Elections in this case. And that was that to declare that this is actually a trial de novo, and that this entire case against the Division of Elections has been an administrative appeal. Right now, I want to make a Rule 50 directed verdict motion, primarily, and I understand this is primarily to observe, to create this record for appeal, and to make sure that this court has every opportunity at this level to consider some of these issues, before the Supreme Court, in the most likely event of an appeal, would take it up. So just for purposes of this motion for directed verdict, just to assume for the sake of argument, that what we just heard was a trial de novo of administrative appeal. And again, we don't agree with that. We're reserving that issue for appeal, but just to conduct that analysis for the purposes of this motion. When the complaint in this case was filed on July 29th. And in that point, I think it was not technically untimely as an administrative appeal. That typically administrative appeals must be made within 30 days of the final decision, but we do have case law from the Alaska Supreme Court indicating that deadline has to be contained in the final decision, which was not in this case. So even though it was more like 6-7 weeks after the administrative decision, it probably wasn't technically untimely. But the key thing is that even though the plaintiffs filed on July 29th, they didn't do anything with this case until after the primary election. There was no request that the court do anything. There was no motion for expedited consideration. The plaintiffs first filed anything substantive after the primary election. So the primary election, I think, was on the 16th, and the plaintiffs' filings for the preliminary injunction motion and expedited consideration were the 22nd of August. And at that point, after the primary election had occurred, then the administrative decision about whether or not Representative Eastman should appear on that ballot was moot. And Your Honor, I'll give you a citation for this. I'll refer you to Mullins versus Local Boundary Commission. And that's at 226 Pacific 3rd, 1012. It's Alaska case from 2010. Again, that's 226 P 3rd, 1012, Alaska 2010. And in that case, that was an administrative appeal of a decision to put a ballot initiative on the ballot. And it became moot after the election took place with the initiative on the ballot. We heard from Mr. Dedukian a moment ago that the result of his client succeeding in this case would be, quote, that to automatically reverse the Division of Elections decision. Reversing, it is now moot to reverse the decision to place Representative Eastman on the ballot. Reversing it has no effect. The thing happened, it is simply done. Reversing it does nothing. The only way for this court to change the outcome of the election is to enter an injunction against the Division of Elections, to order the Division of Elections to not to certify the election as it is already ordered, or to order the Division of Elections to certify somebody else. And that's an injunction. That's not a reversal. So this really is a request for injunctive relief. I think it's important, to consider the analogy I'd give to your honor is, an administrative appeal of a license denial. This kind of thing happens all the time. Someone applies for a license, the agency denies it, then it goes to Superior Court. Maybe the Superior Court orders a trial de novo or not. But the result of that appeal is simply to reverse or affirm the administrative agency's decision about that license. There's no opportunity for the Superior Court to order the Division of Elections to give a different license to the individual, to give a license to the individual that they didn't apply for in the first place. The world of the administrative appeal is about affirming or reversing the administrative decision. In this case, that's moot since the primary election. The other point that I'd make about how this doesn't work as an administrative appeal is that preliminary injunction that the court ordered, again, after the primary election. If this is an administrative appeal, it's occurring under Rule 600 of the appellate rules, not under the rules of civil procedure. And of course, the Rule 600 rules have an opportunity for a stay pending appeal, but there's no opportunity for a preliminary injunction. And the plaintiffs moved for and were granted a preliminary injunction under civil rules. There was nothing to stay pending appeal by the time the plaintiffs made their substantive filing after the primary election. If the thing was done, you couldn't stay it any longer. So even if this case was originally filed on July 29th properly as an administrative appeal, it would have immediately become moot and should have been dismissed as soon as the primary election had passed. One other point here I'd like to make about trial de novo and the concept of trial de novo. Trial de novo is about de novo review of the facts and introducing additional facts beyond the administrative record and making a de novo decision about that. It's not making a de novo decision about the interpretation of regulations that are properly entrusted to the agency. This court should have originally deferred to the Division of Elections interpretation of its own regulations, which, as discussed extensively at the beginning of the case, the division's interpretations of its own regulations is that the word qualifications in that regulation does not encompass disqualification for disloyalty. This court should have deferred to that, and changing this to an administrative appeal and trial de novo doesn't change that duty of deference that this court has to the administrative agency's appeal. It's not a de novo review of the meaning of those regulations, just the facts. I think I won't belabor it since I think I made this argument pretty clearly in my opening statement, but there's also the issue that any claim that this is an administrative appeal was waived, any request for a trial de novo was waived. And in fact, if this claim had been made by the plaintiff, it should have been subject to quasi-estoppel at this point in the case. One last point to consider about the concept that this would be an agency appeal and a trial de novo. There's been a lot of discussion in this case about whether Mr. Kowalke's claims against Representative Eastman could proceed without the Division of Elections. But there hasn't been any discussion of the reverse of that. Could the plaintiff's claims against the Division of Elections proceed without Representative Eastman? And of course, Representative Eastman would not necessarily be a party to an administrative appeal, even to a trial de novo of an administrative appeal. And so that's something else to consider. I mean, the only live question that is not moot in this case right now is the ultimate question of whether Representative Eastman is or is not disqualified from office. That's a claim against Representative Eastman, not a claim against the Division of Elections. And so that's another way in which treating this as an administrative appeal and a trial de novo just doesn't work logically. So I'll just, to wrap this up on this point, to make this motion, we would request as a result of this motion that this court enter directed verdict if this court is proceeding on the concept this is a trial de novo administrative appeal, that it is moot and therefore it's dismissed against Division of Elections, or it's waived and therefore it's dismissed should be dismissed against the Division of Elections. Of course, this court also still has the opportunity, law of the case does not yet apply here. The court still has the opportunity to return to some of its original or earlier rulings in this case. There's still the opportunity to dismiss the case against the Division of Elections on the theory that this is not properly an administrative appeal, it's not properly an election contest, and there's no third way. One last point before I conclude, Your Honor. The focus of this case has, of course, been about the claims against Representative Eastman. But, Your Honor, when you are deciding this, I hope that you will give clarity for the Division of Elections in your ruling. In particular, here we're concerned, or the division is thinking about, if this court rules in favor of Mr. Kowalke and finds that Representative Eastman is not qualified, we would really request some very clear instructions to the Division of Elections about what happens pending, what will likely be the appeal. In the absence of any court order at all, the Division of Elections has a statutory duty to certify Representative Eastman. So if this court intends that sort of the delay of certification, the limbo that we're in, continue through an appeal, the Division of Elections would need a court order to that effect. So we really need some clarity if that's what we're supposed to be doing. If we're supposed to wait till the conclusion of appeal to certify anyone, we need a very clear court order on that. Similarly, if the court is going to order that the division certify somebody else, we need really clear instructions about how we're supposed to do that. I know the court had previously contemplated the possibility of having the Division of Elections withdraw Representative Eastman and then rerun the tabulation using his second choice votes. If that's what we're supposed to do, we need real clear instructions about that. And again, with the understanding that if we're supposed to do that before the appeal, that might have to be reversed if an appeal were successful. So we need very clear instructions to the Division of Elections, what we're supposed to do. And also it's very important, I'm sure, for the constituents, the individuals in this House district to understand exactly what's happening with their representation, at this time and pending an appeal. So that's all I have for you. Unless you have any questions for me, Your Honor, that's all I have today.
No, thank you, Ms. Harrison.
Thank you.
Mr. Dedukian?
Thank you, Judge. And how much time do I have left?
You have 3 minutes left.
3? Okay.
Given the, Mr. Dedukian, I'm going to give you an extra just couple minutes because you have 3 minutes essentially to respond to Mr. Miller's points. I'm going to give you a few extra minutes to respond to the state's Rule 50 motion. Essentially, it's outside what I would consider the scope of closing arguments. I think it's fair to give you a little bit of extra time to respond to that. So it's just a few extra minutes. Mr. Miller, I know you have places to be after this, so I'm just giving a few extra minutes, but there's a lot to cover.
Thank you, Judge. So I'll be real brief in the first part of my comments. As far as the suggestion of any delay, the court has already rejected the argument of latches. There was no delay. If we had filed this case outside of one of the two processes that the court has identified, a primary challenge or an election challenge, we know what would have happened because another person tried to do that and that case was dismissed. So there was no delay. It sounds today like Representative Eastman is challenging the first element, membership in the Oath Keepers, and calling the organization dormant. If you remember from the testimony yesterday, Stewart Rhodes didn't say anything about the organization being dormant. To the contrary, he talked about the fact that an acting president was in place for the organization. And in addition to that, there's a process by which organizations that are actually incorporated, as the Oath Keepers is in Nevada, can dissolve or terminate the organization. And our experts testified that there's been no such filing. Stewart Rhodes said that there are still 5 board members and they haven't taken any action to dissolve the organization. And as far as the emails and letters that were sent, I don't think the court can read or should read too much into the fact that no response was received. Imagine if I sent a letter to Tesla asking the board if they were going to fire Elon Musk for his recent comments and actions, and they didn't respond to me. It's not because they were indicating any kind of point by not responding to me. It's because boards don't typically respond to things like that. With regard to John Eastman, I just forgot to point out a couple of things. One is dual role in this case. He's not only an expert, but He's also an attorney representing, and him and his firm are representing Representative Eastman in this case. Not only was what happened yesterday with an expert testifying as to his interpretations of the law unprecedented, even Dr. Eastman said so, but the fact that he's serving in this dual role really undermines his credibility because there's a conflict of interest there. He obviously has duties as an attorney to his client, and so he can't offer opinions in court that would undermine or conflict with those duties. He also talked about Claiborne as one of the seminal or landmark cases that the court should consider, but didn't even include that in his expert report, which goes to show how important he thought it was. With regard to speech and incitement, even Dr. Eastman testified or admitted that some of the statements of the Oath Keepers were incitement. And it's not really, we're not talking here about people using their speech to contest an election. There's a process for that, a constitutional process for that. It was followed. Not one court found that there was any election fraud. And the fact that people individually think that the election wasn't constitutional doesn't give them the individual right to march on the Capitol or riot. And finally, if I could, as far as what Mr. Miller said about Claiborne and the standard, I think he misstated it. There's no requirement in Claiborne for a person to know at the time they join the organization of any illegal purpose. I think the purpose of an organization can change over time. And as long as they manifest their intent by actions or inactions after they become aware of the illegal conduct, I think that suffices under the First Amendment and the Claiborne standard. And here, again, I don't think that standard should be applied, but if it is, Representative Eastman is in a position of leadership. His constituents look up to him, and his actions and inactions, even after he learned about the violent actions of the Oath Keepers, or at least certain individuals associated with the Oath Keepers, his failure to denounce and disassociate from them, I think, is a manifestation of intent. So for those reasons, we would ask the court to find that Representative Eastman is not eligible under Article 12, Section 4. With regard to the divisions argument, I think, again, I think it was acknowledged that it restates maybe in a little bit more detail arguments that were previously made to the court and rejected, and they're being made for purposes of preserving issues for appeal. I think, first of all, I want to contest the assertion that the division not only did not have reliable evidence, but did not have any way of getting reliable evidence, because not only did they have some evidence that they admit that they didn't consider at all, which is the original Rhodes indictment, and their failure to consider that by itself, which is evidence, it's probative evidence. The failure to consider it by itself renders the decision arbitrary under the law that we cited. But it's also not true that they didn't have the means to obtain evidence. Like I said a couple of weeks ago when we were before the court, this isn't the kind of case where they needed a subpoena power or they needed the ability to administer oaths. All they had to do was to check with other state agencies or the legislature, namely the legislature, to see what information the legislature had on the Oath Keepers. And all they had to do was to search public databases, and they would have found all the information they needed to make a finding. And as far as the suggestion of mootness or the shifting nature of the claim against the division, I just want to say again, the only reason for that is because of the way the division has litigated the case and the shifting positions that the division has taken. So let's start with just even before this case was filed, let's start with the letter that the division sent to Mr. Kowalke denying his complaint. Nowhere in that letter did they say that he had the right to an administrative appeal, and the division concedes today that they didn't tell him about the 30-day deadline for filing an appeal. So that's a denial of due process. If the division was expecting or requiring Mr. Kowalke to file an administrative appeal, that's a denial of his due process rights. And there's controlling law from the Alaska Supreme Court. I think counsel acknowledged it, saying the clock for an appeal doesn't even start to run if you don't notify the recipient of that deadline. So then when we did file the case, the division's initial position to the court was, a legal one, and they said they had no duty at all to enforce the disqualification for disloyalty clause. So the original round of briefing before the court back in August and September was on that issue of law, which is, do they have a duty or not? Because they had taken the point blank position that they don't have a duty at all to enforce that provision of the disqualification or that provision of the Constitution. The court decided that the division did, and then at the very end of the case, right before trial, they filed a motion saying, okay, well, now that you've held that we have a duty, we want you to hold that we followed the proper procedures. And so that's when the attention of the parties shifted to whether they had followed the proper procedures. And then it became essentially akin to an administrative appeal or an administrative review. And the court ultimately decided that it could be that there would be a trial de novo. And the case is also, and so again, I just want to emphasize that's when the question of whether the division followed the proper procedure, did a proper investigation and reached the proper decision, that's when it became an issue that was being addressed and before the court. And in the meantime, the court had preserved the status quo by entering a preliminary injunction, which would have prevented what we were asking for originally is to keep Representative Eastman's name from appearing on the general election ballot, which is what would have happened if the administrative appeal had been filed. And even though the court didn't grant that relief, the court preserved the status quo by saying that his certification wouldn't happen until you decide this trial. So given that basically we've all been frozen in time before the general election even happened, I think that negates any suggestion that the claim is moot. And the court can grant the hallmark or the standard for mootness is whether the court can grant effective relief. And here the court can grant effective relief. It can kind of unwind the clock and say that Representative Eastman should never have been on the ballot in the first place. And so, the court can make final its preliminary injunction requiring the division if Representative Eastman is ineligible to certify the second place vote getter as the winner, or the court can come up with a different remedy. But I think there's no question that the court can grant effective relief, so the case is not moot. And the other suggestion was that maybe if this was an administrative appeal, a more appropriate vehicle would have been a stay pending appeal instead of a preliminary injunction. You can look at the case law; it's functionally the same thing. The same factors apply. It's just called a different thing. One is in the context of an appeal and one is in the context of an original action, but there's no meaningful difference between those two things. The same factors would have been considered, the same relief would have been granted. And then finally, it's just not the case that a court cannot review legal interpretations in an administrative appeal. I think clearly a different standard applies to the factual determinations and the legal interpretations. But both of those things are in the standard of review that the Alaska Supreme Court uses for administrative appeal. So the court can look at it all, and I think the court should look at it all. The court should conclude, based on the evidence it now has before it, that Representative Eastman is ineligible, which means he never should have been on the ballot in the first place, and he should not be allowed to be certified into the next legislature. Unless the court has questions, again, I want to thank you for your time, and I will conclude my remarks.
All right, thank you, Mr. Dedukian. I appreciate the arguments of all counsel and the work that you all have put through this trial. It's obviously been under an extremely compressed time frame, and I appreciate the amount of work and the strain that is put on all of you. And so thank you for your professionalism and your hard work putting through this trial. I have found the briefings helpful, the presentations of all the counsel helpful. So at this point, I'll take both the trial itself under advisement to issue a finding of fact and conclusion of law. My intent is that will be the court's final order. So once that's issued, that would then trigger the time for the appeal. I will also address the state's Rule 50 motion essentially within that findings of fact and conclusions of law. So there's a single document at least that everyone can go off of for the next steps if there is an appeal after this. And Ms. Harrison, I will take your suggestion. I planned anyway, but there will be clear guidance in the order. But I hope to be clear guidance in the order about what will be happening in the meantime, no matter what my decision is. Anything else to take up before we break for the day?
No, Your Honor.
All right, everybody, we got to hear the closing arguments from the state, the plaintiff and the defense. They each gave their scenario of where they wanted to stand on everything there. Of course, Kowalke's attorney, he gave the obvious argument. The actions of other people, what other people did, is the fault of anyone who may belong to the same organization. David Eastman has done absolutely nothing wrong. He is innocent of anything that is trying to be accused of him. He did not participate in anything that the Oath Keepers had done, as the Kowalke's attorney is trying to paint it as. He is one of the ringleaders involved in the center of all of this. He is evil. He is the epitome of what is wrong with the Conservative Party. He must be removed at all costs. He is seditious. He is guilty by association for just being a card-carrying member. I'm a card-carrying member of the AARP, I'm speaking of ages, and things just don't seem to change. Am I guilty of anything that the board members decide to do? They'd plan their own seditious acts like this? And am I going to be guilty because I belong? I received emails from them, never corresponded, never responded, never ever really did anything with them in the involvement of the group itself. They are the Oath Keepers, yet you're guilty by association. The defense did a darn good job. I considered that one a mic drop all the way through. He did very, very well today. He's done very well over the last 7 days of this very long, expedited, sped up trial, and this was a sped up trial. This trial should have been maybe a year from now if we were following normal judicial practices, but no, they accelerated it through because the left, the extremists that brought this case, even though Kowalke, from my understanding, is a Republican that brought this case, this is not the first time they've done this to our representatives, our legislators in Juneau. This is the fourth such case that Kowalke and the people that are the attorneys that bringing this case forward, the fourth time they have tried cases like this in Alaska, not particularly like this one, but going after removing people from office or things along those lines, violations, ethics, you know, the different levels that they've gone after 4 different times. And guess what? It's always been on just one side of the fence. They go after the same demographics, the same political party every single time. What happens when it goes the other direction? We have no idea what happens when it goes the other direction because it just hasn't happened. We're not seeing those lawsuits coming up. So now we got to sit and wait. It's going to be about a week, maybe 2 at most, and the judge will come back with his expedited judgment. He is judge, jury, and executioner in this case. He denied a jury trial by Eastman's peers, and because they don't think, because it's they said it's a monetary thing, because there's no money on the line. Forget about David Eastman's job. He's a legislator. He gets paid there all the time in money for this lawsuit to fight it. Even though there is no monetary value, they claim, in this, that all that is being lost, all the costs that are being incurred right now doesn't count. So because of that, there is no jury allowed. This was the judge's decision and how that came about to be. Forget about the tens of thousands, the hundreds of thousands that this lawsuit is costing. No matter what the verdict is, and I'm going just by what I heard the state say today on their closing remarks, what the defense said in their closing remarks, and what the plaintiff said in their closing remarks. If this judge comes back and awards the judgment to Kowalke, in my mind, it is a 100% confirmation that our judicial branch has been 100% corrupted, and there is no justice left in the world based upon your political affiliation. That this would confirm it, because the defense and the state gave extremely good arguments throughout this entire thing. The defense has been right on top of it all. Even when the plaintiff, Kowalke's attorneys, had brought out all those clipped videos, making sure that pieces of speech that President Donald Trump had given during his rallies were the same clipped ones that the January 6th committee was presenting during their testimonies. You can find those videos on our videos that we've streamed for each day. So if a video was shown during that day, you will find in the comments, in the comment section, you will find links to those videos of the unedited that was also played there by the defense, countering what Kowalke's attorneys had done. The star witnesses of Kowalke's attorney were all far left extremists that were supposed to be experts, and I'll emphasize that they were supposed to be experts when it came to the everything Oath Keepers, and they couldn't even tell you how many members were in the Oath Keepers. They're not experts. They couldn't tell you about any other domestic terrorist group in America unless it was the Oath Keepers or what they classified as the far alt-right extremists in America. That they had no clue about Hamas or anything else that may be in our country. In the organizations that are there, or Antifa. Oh, what's Antifa? I have no idea. Challenge of the day, go to antifa.com on Google. You will find yourself, unless they've changed it, and then last time I checked they haven't, it'll take you directly to the White House's press release page at the White House and their website. So that just tells you, and during the campaign season, if you type that in, it took you directly to Joe Biden's campaign donation page. So it's following Joe Biden around wherever he goes. And that just tells you where the organizations really are, why they don't exist in the public eye to anybody out there, and why it's covered up. Ray Epps was brought up during the conversations, or the trial there, and who is Ray Epps? What role did he play? And of course, everybody wants to deny this person ever exists. The video, though, shows a lot of what Ray Epps was doing out there. We all want to know who this guy is. And what role did the FBI play in the insurrection, as they call it, but I call it just a riot that happened at the Capitol that day? Those bad apples, those people that I don't know a single American, no matter what party they belong to, doesn't condemn for what they did on that day. Even Stewart Rhodes, the founder of the Oath Keepers, who gave tremendous testimony. I thought it was pretty powerful testimony. I mean, depending on which side of the party you sit on, you would either consider what he had to say as condemning. Look at what happened there. But if you really took the time to listen to what he said, that was not their mission, why they were there. Going into the Capitol was not what their organization was there for. Those rouge members, that's one of those tongue twister words for me today, that broke away and went into the Capitol, they did that on their own violation. They had nothing to do with the Oath Keeper mission and why they were there at the Capitol that day. And that is not the way they want to paint the actions of those few. They want to blame all 38,000 chapter members to the Oath Keepers as being the fault of the 0.0015% of the Oath Keepers that entered into the Capitol that day. Yes, that percentage is right. You can calculate it out. When they say there was 30 people plus that have been charged, 60 plus supposedly that were in the Capitol that day, inside the Capitol that day. Out of the 1,000 people, that makes less than 3% of the 1,000 that was inside of the building. And then you look at the total calculations of the entire amount of people that were there at the Capitol. They're estimated, and they gave estimates depending on whose witness you were talking to, anywhere between 500,000 and 1 million plus people there at the Capitol on January 6th. Why don't we ever hear about that million people that were there at the Capitol that day? Why don't they ever throw that number out there? Because they want you to focus on the 1,000 people that broke into the Capitol and did the most horrendous act that had been perpetrated in modern times, in my opinion. And those people that entered that Capitol, they deserve everything they get. But you should not be guilty by association. I mean, your union, you had a union member inside of there. Your union's now entirely guilty of sedition, and every union member that you have, because one of your union members has gone into the Capitol on January 6th, they need to lose their job. And anybody that is a part of that organization should really be considered losing their job too, because they're a member of somebody that broke the law. This is what they're doing to David Eastman. So wake up, folks. Share, like these videos. Every single day I've been there streaming the trial. Share those videos. Alaskans need to educate themselves. Our liberties, our freedoms are all on the line. And this holiday Christmas season is no exception. We need to help out everywhere we can. Help out David. Go to davidlegal.org. That's DAVIDLEGAL.org. And go make a contribution to him right today. This is going towards helping to fight all of these legal battle that he is currently fighting right now. Every penny is going towards his court case. He is well over $100,000 in fees. He is expecting somewhere probably around $500,000 in attorney fees before this is all through, because expect this to go to the Supreme Court next. If it doesn't go to the Supreme Court, we'll all be shocked. I tell you what, I'll be shocked if this doesn't go to the Supreme Court, because I don't see the left giving up on something that they think they've got a winning strategy for. They're making it work elsewhere in the United States. 4 other people have been put under the microscope for just the same thing. Difference is several of them are actually inside the Capitol participating. But out of all 4 of them, not all of them, several more of the majority, not the minority, were not inside the Capitol that day, just like David Eastman, and they're being classified guilty by association. And this is, our liberties are on the line, our freedoms are on the line. Where is it going to stop? Who's going to be targeted next? Where is Alaska Ledge? Where's our Alaska legislators? Where's Governor Mike Dunleavy? Hey, politicians, I'm calling you out. You know, where are you? Where is our government and our local representation standing up, fighting this battle side by side with David Eastman right now? Why are you not in the trenches with him, fighting for our rights and our freedoms and our liberties protected under the Constitution of the United States of America and Alaska's own very Constitution? You guys are using Red Scare laws that was made back in the 1950s and 60s, back when things demanded that kind of scrutiny for the thinking that was happening back then. It does not apply in modern times. We're 50 plus years since then. Catch up. Diversity, equity. Come on now. You guys want to keep living back in the eras when it suits your needs, but the minute it doesn't, you want to claim modern times. You got to change. You got to accept. There's more than one kind of, you know. Anyways, we need to stand up and we need to unite. And one way you guys can help David out is, again, go to davidlegal.org and make a donation to him. All the support he can get, it's well needed. This is a long, long case. He has everything on the line. This is not being paid for other than out of his own pocket. He doesn't have no Republican Party RNC backing that's paying for these lawyer fees that he's having to incur for this trial that has happened and all the costs leading up to it. He needs help. Unlike Kowalke, whose backing is coming from Soros-backed money, far-left organizations that, again, I'll point out, this is the 4th time they have sued in our state. These same people have sued in our state, going after Republican conservative legislators. And they have not once, and there has never been a case or a trial brought against those on the left. It has always been in the Conservative Party the last 4 times. And this is just a pattern. The more they keep getting away with it, the more they're allowed to keep media putting out their narrative and their 30-second spin about what's happening. That's what they're going to do. That's why we got to share videos like this one. Like, share, subscribe, click that bell, get yourself notified. Go to rumble.com/Politidic and subscribe there. We want to reach 100 viewers there. We want to stream live to Rumble. Help us reach that goal. Go and subscribe to Rumble. Don't even have to go there and do anything. Just subscribe to Rumble, you know, make a little account, and then subscribe to our page at Politidic, and you're done. You'll never ever have to go back there again. But we need to reach 100 people. We need to be put onto channels that we can't be canceled on, that Facebook, YouTube censors can't shut down, can't delete our videos, can't ban our videos. I've done over 500 videos that are supposedly supposed to be on YouTube, and I'm only showing 355 there. And that number never seems to grow, even though you guys are watching it right now, probably on YouTube, some of you. And but that you're not going to find, you might not find this there later on, because they're silently removing several of my videos at a time. And we need to get on a channel that is uncancelable, uncensored. We're also working to get on NorthTube. We don't need subscribers there. We just need a stable connection to actually live stream to it. Currently, we trying again today. I don't know if it showed up on NorthTube, but the last few days, my services are saying we're not connecting. It's not streaming there. So I'm not quite promoting that one just yet. But rumble.com, help us grow. Help us subscribe there. Let's reach 100 subscribers so we can stream to them live. This is the wrap-up. Kowalke versus Eastman's case. If you guys are can help them out, go to davidlegal.org. Make a donation towards his legal costs. Help him out. He needs everything he can get. Soon, we here at Politidic will have our website back up and running. We're having DNS server problems trying to get our registration changed over to a new web host, and the old web host is battling us. They are not releasing anything. I have already put in the steps to work on getting it transferred somewhere else so that it would no longer be under that web host's control at all, and be put in somewhere where our website will be uncancelable and a lot faster. You don't have to worry about getting a cup of coffee and coming back. You'll blink and there it is. That's what we're hoping we're moving ourselves into. Be patient. Once it's back up running, please go to our website, politidic.com, and click that support button. We need help. We need to continue to keep doing what we're doing. What I'm doing is not free, and I'm not a rich person. I don't make a lot of money at what I do. I run my own business on the side. In fact, in the last week and a half now, I have told a lot of my customers I can't come because I'm doing this. And your support is what's helping to cover those costs that I'm losing right now, because I can't go and do my normal job. But thank God, I love my customers. You guys are a blessing out there. If you know who I am and you're watching this right now, you guys are a blessing for understanding that my passion to cover what mainstream media won't do is a plus, and you guys all have supported me in every step of the way, and you are greatly appreciated. And for an anonymity, you know who you are. And God bless you guys. You are greatly appreciated. Christmas is just around the corner. We are just a couple of days away from that. And get this thing out of my ear. Don't need it anymore. I can tell I've definitely been talking to you. And I hope you got everything you needed for Christmas this year. That the Santa lists have been filled out, and they have been sent off to Santa. As you can see over there. Oops, wrong side. There. You can see up there up on the roof, I've got Rudy the reindeer. He has a note attached to his backside, and he is going to be on his way to Santa this evening to go deliver the final Christmas wishes of my kiddos here in the house for what they want for Santa. And, you know, hopefully Santa will be able to get that list and be able to fulfill their wildest dreams. They have both been wonderful, beautiful kids all year long. They are definitely not on the naughty list. Me, on the other hand, I'm on the naughty list. You know, you can't be on the naughty list when you're a conspiracy theorist that always seems to come out right. The elves, I contacted the Elf Guild, and they told me outright that I am definitely on the naughty list. Their fact checkers have been checking me, and they say one too many of my conspiracies have come true. And because of that, I am on the naughty list. And so socks and underwear, once again, is probably what I'll end up getting. I'm never bad enough to get coal in my stocking, but, you know, this year I asked Santa to send someone over to shovel my roof. I'm crossing my fingers, but I don't think I'm going to get that lucky. Again, hope you guys all have yourselves a very, very Merry Christmas. And once our website's back up and running, you can find this live when we are live at politidic.com/live. The videos will always play live there. Again, once we get the site back up and running again. This video right now can be found on Twitter, YouTube, Facebook, and Rumble. all at Politic, and you can also find it at Politic Unfiltered on Facebook. That is just a streaming channel for our videos only. That's always an alternative to hopefully get a notification from them. Please click the notification bell if you are on YouTube, and so you get a notification. Facebook is picking and choosing who they want to send those notifications out to. YouTube isn't doing that. They're sending them out every time. I even received my notification I was live doing this here right now. That just tells you how good it is. Yet Facebook never sent me one. So hopefully you watching right now, you've liked and shared this video. Have yourself a very Merry Christmas. I don't know if I'll be back on before Christmas again, but I'm sure I'll come up with something. You guys all have yourself a great day. Stay warm. Make sure those cars are plugged in a couple hours before you need to leave anywhere. And hopefully your Christmas stockings are filled with plenty of Christmas joy. Have yourself a very, very Merry Christmas.